ordering interim measures, they are very broad. They say the arbitral treatment may order whatever it deems appropriate. In practice, the arbitrators in the Stockholm emergency arbitration are Swedish guys. So they mostly appoint Swedish arbitrators for these proceedings, and in my client cases it was also Swedish guys. They speak about, at the beginning, about lex arbitri, about Swiss law, all those general principles, and in almost all cases they all rely on the Mistral model law as provided for those three pillars: the irreparable harm, the prima facie possibility of success, and the urgency and proportionality. But in emergency arbitration proceedings, the focus is really on urgency. We discussed it before the break briefly, and we'll discuss it in a little more difference later. But in practice, to plead these criteria, to persuade the tribunal that the measures requested do meet these criteria, the bodies are required to demonstrate a little broader range of standards. And I will discuss them one by one. On the prima facie possibility to succeed on the merits, it's interesting that in the practice of the Stockholm emergency arbitration, in all cases that were accepted and decided by the emergency arbitrators, the arbitrators found that the claimant had prima facie established that had a reasonably good case. So it shouldn't be very difficult. Yeah? But the one, it's pre-arbitration procedure. So the parties have not exchanged their submissions. They have not filed their evidence. They have not relied on experts, witnesses. There's nothing in the case filed. There's probably only request for arbitration. And if you had a chance to work on Stockholm arbitration, you would probably know that a request for arbitration in those proceedings is a very, very brief document. And if it's drafted by the Swedish office, it will be like a 3-page document sometimes. But probably at this stage, if a party is contemplating emergency arbitration, the request for arbitration will have to be a little richer, so to say. The parties will have to not only state the facts, but probably provide some substantiation for that. And the tribunal will, the emergency arbitrator will have the difficult task of not estimating the chances, but just ensuring that the chances are there. Because estimation of chances probably wouldn't be really a proper function at this stage. You know this funny story when a blonde girl was asked, what are the chances of meeting a dinosaur when she gets out of the room? And she said, well, it's like 50-50, either meet a dinosaur or I don't know. In reality, the chances of meeting a dinosaur converge to zero in this situation, right? So the task for the arbitrator will be probably to ensure that the chances of the party are not converging to zero. The arbitrator will have to, of course, check if the parties have a valid arbitration agreement entitling them to covering the scope of the dispute, of the potential dispute, and prima facie substantiation of the case. And in the emergency arbitration procedure, the respondent is given a chance to respond. So it's quite important for the arbitrator as well what is stated by the respondent. If the respondent does not, in principle, deny the claims, but maybe denies the quantum of the claim, or says that this claim is, well, maybe this claim is really bad and I have serious objections to it, then the arbitrator will be much more persuaded that the claimant has reasonable chances to succeed on the merits. It's still difficult, but it can be. However, the arbitrator will keep in mind that the requested measure should not create any prejudgment on the merits. At least least in 2 known cases under the Stockholm rules, the measures were rejected precisely for the reason that they were, so to say, predetermining the decision of the tribunal, which would have to happen at a later stage. The emergency arbitration under the Stockholm rules lasts 5 days. So you file, the case is transferred to the emergency arbitrator on the next day, and then the matter is decided within 5 days. And in many cases, the arbitrators comply with this deadline. In my case, my recent case, it was all finished in 8 days. But in that case, the institution needed another day because they could not create an exhibit. So 5-6 days is reasonable. It's really the time they need to decide this case. And when the parties virtually ask the emergency arbitrator to decide their case on the merits, it cannot be done in 5 days. And of course, such a request will be refused. The other side of this rule is that the awarded interim measures have no effect on the decision on the merits, which will be later passed on by the arbitral tribunal when it's constituted. In other words, they will have no res judicata. And at least in 1 known cases, the relief was rejected, was not granted because the party was asking declaratory relief, rather than asking the other party to do something or to not to do something. They were asking for a declaration. But on the other side, a request for interim relief can provoke a declaration from the respondent. And in my client case, it was a very good outcome actually. Although we lost on the interim measures, we were not awarded those measures. But the respondent committed to payment, and in fact made a payment soon after the interim measures procedure was accomplished. And if a party commits itself and makes a declaration that it's, for instance, considers itself bound by an obligation but doesn't think it's yet mature, for instance, it will make it a trouble for this party to deny this obligation at a later stage in the arbitration. And the party will be risking losing credibility in the eyes of the arbitrators. Well, certainly, like in any arbitration, in emergency arbitration, all claims should be directed at the party to the arbitration agreement. And interestingly, there was already a case under the Stockholm emergency arbitration against a state party in a treaty-based case. And in that case, the party was ordered to not to take certain measures, but of course the state party could not take those measures. Its authorities, its agents would be taking or not taking these measures. That's a little tricky, but in terms of investment treaty arbitration, I think it's a very reasonable decision. Well, the claimant will have to show that unless the interim measures are taken, there will be a loss and injury, and this loss and injury would arise from the respondent's action or respondent's inaction. And because quite often, and in the case law of the Stockholm Institute, there were cases when the interim measures were rejected, precisely on this ground, because the claimant was asking to bind someone else, or was complaining of someone else's actions, as actions which may result in injury or loss. This may include a subsidiary or a joint venture of the respondent, for instance. And a good question will be if the respondent can really influence the decisions or actions of that entity at all. And if it can, then it will be probably a task for the claimant's counsel to properly draft the request for interim measures so that it's not aimed at the third party but aimed at the respondent and binds the respondent to, for instance, issue some instruction or force its subsidiary to do something. It's workable. terms of urgency, well, urgency is, in terms of emergency arbitration, is specific indeed. In many cases, in most cases, the parties lost on the matters of urgency or irreparable harm. In our case, we lost on the matter of urgency. We could demonstrate urgency in terms of interim relief. So our urgency would be important enough for interim relief to be granted in arbitration. But the arbitrator was not persuaded that it was important enough at the pre-arbitration stage, so before the tribunal is considered. And it's indeed very difficult to demonstrate the urgency like this, that it's a matter of days or a matter of several weeks, for instance. In most cases, I think the parties could only demonstrate this sort of urgency if they can provide evidence of the assets disappearing or the respondent disposing of some property. Also, the matter of urgency can be very well outweighed by good representations made by the respondent. If the respondent says, I am not taking any actions, I am not selling the asset, it will be difficult to persuade the emergency arbitrator to take these emergency measures before the tribunal is considered. Issues of irreparable and serious harm is very often connected with urgency, and of course they go hand in hand. So, in fact, what's serious and how irreparable it should be? And the most important threshold here is whether this harm can be repaired by a subsequent damage claim, for instance. The claimant may be very disappointed, may be very annoyed by non-performance by the respondent, but if it can't be dealt with a money claim, I think there's very little chance to get an emergency arbitration decision in his favor. On the balance of interests and hardships, it's really the matter of, in my view, of persuading the arbitrator, of making him or her comfortable with the alleged difficulty of the situation for each of the parties. Both parties will be complaining of the terrible difficulties created by taking interim measures or not taking interim measures. Both parties will be unhappy. But I think what the arbitrator would be more or less comfortable with is granting a measure which does not disrupt the respondent's business, does not disrupt its day-to-day activities, and does not run contrary to the ordinary course of business of the respondent. However, in some cases, it may be outweighed by, for instance, manifest obstruction or clear misconduct, or maybe allegations of some really illegal behavior of the respondent. In that case, the tribunal might be more positive towards the interim measures requested by the claimant and might grant something even really burdensome on the respondent. Again, in my view, the arbitrator should ask himself whether the measure granted is repairable itself. If the arbitrator, so to say, makes a mistake and the respondent later prevails in the arbitration and can the respondent cure his harm from this abused interim measure then? And this is the topic of sanctions. I wouldn't really like to go into that in detail, but in many legal authorities, you would read the recommendation that the arbitrators thinking about interim measures should also think very well if those measures, if imposed, would create some liability for the respondent. If they would be conflicting with legal obligations existent for the respondent under the law or under some other agreements. But I think in practice the arbitrators, especially the court judges, often forget about this factor. Well, just to sum up, I would like to say that in Stockholm the number of cases is pretty similar to the ICC so far, but they started a little earlier. But we're speaking about the cases which proceeded to be considered by the emergency arbitrator. Only 4 requests were granted out of 14, and most were rejected on the urgency or irreparable harm grounds. And in 2 of the cases, the respondent made explicit undertakings which persuaded the arbitrator that it was not necessary anymore to impose an interim measure. But it was probably not a negative outcome for the claimant. But my client was quite happy with receiving the declaration by the respondent that they remember the liability, that they have accounted for it in their managerial reports, and they do plan to pay, but in due time, in their view. So, in my presentation, which will be sent to you by the organizers, I also include some information on cases under other institutions, and the references to the cases and to the legal authorities I was analyzing before making this in the notes to the slide. I wanted to, as a final remark, I wanted to raise an issue of one of the cases with regard to opt-in, opt-out situation. Although it's not real opt-in, opt-out, but under the Stockholm rules there was one case where this issue was indeed raised by the party. The respondent was objecting that it stated that it did not agree to the emergency arbitration. It only agreed to be bound by an award rendered by the completely constituent tribunal. But the emergency arbitrator denied this argument, and he analyzed 2 issues. He stated clearly that the parties, by agreeing to the rules, agreed to the rules and to every rule, including appendices, including all articles, including all sub-articles, and whatever. Although the arbitrator stated that it was irrelevant to this case, he proceeded to analyze whether the parties indeed understood what they agreed to. And judging by the language of the clause, which was a little more complicated than the model clause, for instance, the arbitrator said that he understood that the parties did look into the rules, indeed analyzed them, and did understood them. So they were sophisticated enough to understand the peculiarities of the rules when they agreed to them. Well, here I conclude, and if you have any questions, you're welcome, please.
I have one. In your experience, or based on the cases you reviewed, how common it is for the arbitrator to inquire about the ability of the claimants to cover potential damages caused to the respondent by the measure applied, or to request additional security for those costs?
No, not really. In our case, it wasn't asked, and in judging all the limited information provided about each of the cases, because all those cases are commercial cases except for one, and they are confidential, of course. They are not published in their entirety. Only a summary is published by the institution. But judging on this, I didn't see any cases when any money was requested to be, for instance, deposited by the claimants. And I should say that the arbitrator does not ask questions. The arbitrator sets up a timetable, invites the parties to make their submissions, and then decides the matter on the basis of the submissions. In our case, the respondent did not raise this issue. I think if the respondent would raise this issue, maybe we would have to comment on this somehow. But I don't think the emergency arbitrator has time or ability to decide on this. For instance, you can't really do that within 5 days. I think even if the arbitrator is entitled to do that, he will avoid trying to avoid.
My question is not exactly connected with the emergency measures, but with the arbitral jurisdiction to order provisional ones. Is it possible to agree to arbitration, but to exclude the arbitral's jurisdiction to order a provisional
exclude?
Yeah.
I think yes, why not? Unless there would exist a set of rules which says that it cannot be excluded. But I have not seen a set of rules like that. The parties are the owners of the arbitration. The arbitrators can only do what the parties agree them to do. The parties can ask the arbitrators to motivate the case. The parties can ask the arbitrators not to motivate the case. The parties can say that please decide all our disputes, or please decide all our disputes, but not delete. No, I think the parties can exclude the jurisdiction of the tribunal over any interim measure request.
Maybe I will intervene in this discussion, but of course there are no strict rules that parties cannot exclude. The possibility to the arbitrator to grant the interim relief. But anyway, almost I think in each country, in each known country from which parties of the arbitration come, they do have possibility to file the request for interim measures at the state court. And of course, there is no possibility to waive from this right.
At least in Russia, right?
Yeah, there is a possibility, in fact, to waive from this right in common law jurisdictions. But when we are talking about European Union countries, it's also possible, but not with in such a wide perspective, and it's impossible in Russia, China, India, in Asian jurisdictions, even being the followers of common law system. So I think that it's a way of do not only legal process between the parties, but the way to do some business and political decisions between parties on how to follow, whether to persuade one to have the possibility to think that they exclude the interim measures in arbitration and to use them effectively in national courts. It's a matter of politics rather than it's a matter of litigation.
Yeah, I don't think it's pretty reasonable for the parties to exclude it. Although, yeah, that might save money maybe to the parties if they don't have this possibility in arbitration. So in my experience, it wasn't very expensive.
Maybe a follow-up question. There is obviously a chance to exclude most provisions of ICC rules or other institutional rules, but we, as an industrial model law country, have this Article 17 provision in the law. And is there a possibility to exclude that provision of, Article 17, which provides for the same interim relief and the possibility of the tribunal to grant this?
I don't think this article provides for a possibility for the tribunal to do anything. The parties agree to some rules that govern.
So it's not right.
No, I don't see how this article is applicable to that.
Oh, okay. Thanks.
So, I guess if no more questions, I just pass the floor to my colleague.
So my presentation and possible discussion between you and me on our narrow circle will cover the issue of national support say interim measures that could be granted by national courts in support of arbitration in Russia or abroad. But I will start not with the analysis of the issues related to interim measures themselves, but rather from the such very essential point that in each case you as a lawyer is trying to get interim measures either from arbitration or national court. It's not in fact a matter of law, but in fact it's a matter of business coming from your client. Because when you're a lawyer, you're only asked for the client to protect his interests. And it's not up to you as a lawyer, in fact, to decide whether interim relief should be granted or you should file an application to get an interim relief. But rather, it's a direct will of your client. In each case, you will be granted by the court, by the tribunal, by interim relief. You will be praised by the client. You will get a accolade. We can in fact divide the situation with interim relief into big groups. The first one, of course, when you are acting on behalf of your client and when interim relief and interim measures will allow your client to protect his interests and to, for example, stop doing the second party something bad against the client. The second big part of interim reliefs that could be granted, they in fact allow your client to do something in his favor rather than given as providing the obligation for another party not to do something. But again, this is a question of the client policy, but not of your legal practice and on case strategy itself. These are my thoughts. They can be supported or cannot be supported, but our practice shows that almost in each cases we've been involved, the request for interim relief came from the client, rather from a lawyer involved in the case, and almost in each case the request for interim relief that has come from the client has at the end the interest of business raises the interest of legal protection. But let's move forward to the presentation and to the issues related to interim relief could be granted by national courts in Russia in support of arbitration. The first thing we should know, and the first thing that we should accept, is that the development of different issues related to interim reliefs in Russia had quite a long story. Started not even in 2002 when the arbitration procedure code was adopted in Russia, but rather in 1993 when the law on international commercial arbitration was adopted in Russia. Since then it was changed only in 2008, but it was only cosmetical changes, slight changes that in fact does not reflect the current political and legal situation not only in Russia but worldwide. So the general approach of Russian state courts in granting interim relief in support of arbitration or granting a court order in support of interim relief granted by an arbitral tribunal was quite proactive from the point of view that Russian courts were not supporting interim measures issued by the arbitral tribunals or they approach was quite formalistic, and the issues of public policy and the preliminary character of arbitral order granting interim relief were considered quite widely by Russian courts, and from this perspective, of course, at least until 2011, 2012, Russian arbitration courts were simply declined the requests of lawyers and clients asking to grant an interim relief in support of arbitration or applications to support arbitral orders granting interim relief in arbitration. But things changed in 2000 and late in 2011, 2012, and then were supported in 2013 in quite very well known document issued by the former or the merged or deceased yes, the late Supreme Arbitration Court in Russia that were saying about the court practice involving foreign participants in Russia. First of all, till 2011, the Russian arbitration courts, when declined to grant orders related to interim relief in support of arbitration, as I said before, had a very narrow approach from the legal point of view and a very wide approach when analyzing the legislation. First of all, when declined application to grant an interim relief for Russian state courts, were saying that first of all, the interim relief granted by an arbitration or application for interim relief from a Russian state court would not follow the Russian law. First of all, because when, for example, arbitration the arbitral tribunal has granted the interim relief, they simply didn't manage to study the case, and it was some kind of document issued in a summary fashion way when this is what Irina was talking about, for example, when there were no real arbitral deliberation, when the case were not started itself, and so on and so forth. When, for example, the parties in Russia were asking to grant an interim relief under the provisions of Russian law and in support of arbitration, in this case, Russian courts told parties that, okay, in fact, you have the right for an application, but your application will be declined on the basis that simply Russian arbitration procedure code does not provide a strict provision which we could follow in granting your application in support of arbitration. Because, for example, clause 19 of arbitration procedure code, from a point of view of Russian state courts, were not covering the issues related to interim reliefs in support of arbitration abroad or even in Russia. But as I said, late in 2011, in 2012, the courts in Edimax Limited against Shalba Chigrinsky case granted interim relief in support of arbitration. And I think it was the first one, application in support of arbitration that was granted by the Russian state courts. In this particular case, Edimax Limited, acting as an applicant, was asking for interim relief against Shalva Chigirinsky and filed for a freezing order against his assets in arbitrage court of Moscow. But as I said before, the court of the first instance said that, okay, you have the right for an application, but following a very formalistic approach, we decline your application for interim relief in support of London arbitration. Then, in the appeal court and in the cassation court, the situation changed dramatically because the appeal court supported the court of the first instance, the cassation court changed the court rulings and said, okay, the party does have the right to file the application for interim relief in support of arbitration abroad, and it also should be granted because the party provided enough evidences that the emergency actions should be taken and the assets should be frozen only from the positions that we know Shalva Chigirinsky quite good, and all his previous actions made during, let's say, normal business activity show that in case when he was suited in Russia or abroad, the assets just disappeared from the case. And finally, the case came to the Supreme Arbitrage Court under the supervisory appeal filed by Shalva Chigirinsky's wife. She was saying that I disagree with all court rulings and with all orders because Shalva was acting in person, but at the same time we were wife and husband, and okay, he provided some so he secured, in fact, the transactions by his assets, but his assets